Morning, everyone. We're just going to give it another minute and then we'll start. So we'll make a start now. So good morning and thank you for joining us for our latest webinar about coming out of lockdown. My name is David Seals and I'm joined by Nicola O'Dwyer. We're both partners in the Employment Department of Down Solicitors. This webinar is going to be probably about 50 to 60 minutes, depending on how many questions there are. If you want to ask a question, you'll see there's the usual box there at the bottom, so please do put your question in there and we'll do those at the end. The webinar is being recorded, okay, but the recording will stop at the point we start doing the questions. So here's what we're going to be doing on the slide. I'm going to be looking at vaccination and workplace testing and annual leave, and Nicola's going to cover the other topics. So, first of all, vaccination. Can you make it compulsory? So if we have the next slide, please. So clearly you will have seen this in the news and in wider society, the government are looking at vaccine passports, which we may need to get on a plane or go into a restaurant, and the government are looking at that. They've got that under review, and I think they're going to be making a decision June time as to what they're going to do about that. And you'll have seen in the newspapers the sort of controversy around that, whether that will create a two-tier society. We are concerned, of course, with the workplace. And that brings up the issue on the slide here about no jab, no job. So we're going to look at what employers might do and what the consequences of that could be. Now, just as a bit of background, there's no legal requirement to have a vaccination. In fact, the opposite is true. But that doesn't stop employers requiring employees potentially to be vaccinated. And on the slide there, we put the two ways that might go. It may be that this is just something on recruitment, that employers say you've got to be vaccinated or you can't get a job here. Or they may look at their existing workforce and require them to be vaccinated or face consequences such as suspension or change of duties or potentially dismissal. Now, it's worth just bearing in mind in the background that the vaccine is, of course, not 100% effective, and also it's still emerging as to how it stops how the vaccine would stop transmission of the disease, even if you've had it. There's something in today's news I saw on that, which is quite interesting, because it seems to be saying that if you have the jab, it is going to quite significantly reduce transmission of the disease, even if you're asymptomatic. So if we go on to the next slide, requiring someone to have a vaccination at work, if you think about it, is quite a significant intrusion into their privacy. After all, you're asking them to undergo what is a medical procedure, albeit perhaps a minor one. But employers could have good, credible reasons for wanting this, and they're set out on the slide here. So first of all, in some workplaces, the employer can make a good argument for saying it's actually necessary to do the job. And the obvious cases are things like people who work in care homes, frontline healthcare staff who are coming into very close contact with members of the public. Then there might be other employers who see this as important because their workers do have some contact with the public. So I'm thinking about the Pimlico plumbers chap who was in the news a little while ago, and he's been in the news before on unemployment matters. But he popped up recently saying if anybody wants to come and work for his company, they're going to have to be able to show they've had the vaccination. And you can see there's an argument for that. If you're going into people's houses, you're going to be coming into contact with members of the public. You can see that they're going to feel safer potentially if they're using a company where they know all the workers have had the vaccination. There could be a much wider reason why employers might want to have the vaccination. This just feeds into their statutory duty to provide a safe workplace. And of course, that may be very reassuring for other people that work for that company. They may be quite happy to have the vaccination, and they may feel reassured to know that all the other staff there have had the vaccination. Others, as I say, will find it a real intrusion on their privacy. So if we look at the next slide. So how might employers do this if you decide that you are going to insist on staff having the vaccination? How might you provide for that in your documentation? Well, there's various ways you could do it. One thing would be to change the employment contract to actually put an obligation on employees to have the vaccination. You could have a written policy on this, or you could just have an unwritten policy, just issue a simple instruction. Now, why does this matter? It might matter quite a lot if there's some fallout from this and you face claims later. A tribunal may look very carefully at how you incorporated this requirement into your employment documentation. If we just look at these, a change to the contract, that would clearly show that you're very serious about this, and it is a requirement of the job. But changing contracts is not easy. Generally, it's going to be time consuming. You're going to have to consult with staff about it. And if people refuse to agree the contract, then you've got a difficult decision to make, because you might have to dismiss staff with the offer of re-engaging them on new contracts with the clause in there requiring the vaccination, which they may not sign up to, and they may bring claims for unfair dismissal if you dismiss them in those circumstances. Now, if that went to a tribunal, the employer may have a sound business reason for insisting on that change to the contract. Cases are going to vary so much. It will depend on the workplace. You can see that frontline healthcare workers and care staff, where those kind of employers insisted on a contractual term requiring the vaccination, those kind of employers are probably going to be able to show a sound business reason. Not so in the majority of cases, I would think, where that kind of contact with the public or contact with colleagues even is not such a risk. Now, as I say, you could just introduce a written policy, but ideally, again, you would want to consult with staff about that. And again, that might be time consuming. We go to the next slide, please. Next, I want to think about claims that you could face if you do this and it doesn't go well. Well, there's potential for a lot of different claims here if you do this. Unfair constructive dismissal. So I'm thinking there of the situation where perhaps you require your staff to be vaccinated, you get people who refuse it, and because you feel you obviously have to enforce the decision, the policy decision you've made, you end up suspending them until they change their mind, or maybe you change their job, make them work remotely where they weren't before, give them duties where they're not coming into contact with other members of staff. Well, an employee in that situation might feel that that is a fundamental breach of their contract. This is the implied term for trust and confidence. It's in all employment contracts, and a suspension or change of duties in those kind of circumstances might give rise to that kind of argument. If somebody felt their contract had been breached in that way, they could resign and claim constructive dismissal. Now, a tribunal looking at that would have to determine whether or not that was a fundamental breach. And if they looked at that, no doubt they would be looking at the workplace in particular and the employer's justification. So those kind of cases are going to vary depending on the workplace and how good a case you could make for requiring vaccination in your business. Unfair dismissal claims, of course, so if you dismiss someone because they refuse to have the vaccination, if they've got 2 years service, they'd need that for unfair constructive dismissal as well. If they've got 2 years service, they could bring claims for unfair dismissal. And again, those kind of claims, the main focus is probably going to be on whether or not there was a potentially fair reason to dismiss. And that's for the employer to show. Now, the employer in an unfair dismissal case like that would probably rely on conduct as the potentially fair reason to dismiss, i.e. that they'd required the vaccination and that this was the policy of the company, and the employee's refusal to comply with that was refusal to obey a reasonable management instruction. So that could be a conduct dismissal. They may rely on something called some other substantial reason, which the Employment Rights Act allows as a potentially fair reason to dismiss as well. What about discrimination? So this is quite possible. Take that first case of putting a job advert out saying, you know, we want workers, but you've got to have the vaccination. Does that discriminate against some people? Well, potentially it could be indirect discrimination. It's indirect discrimination because you're applying it across the board. You're applying it to everyone, but it could have an impact on certain groups. And on the slide there, we picked out some relevant groups. So age is relevant because when I checked yesterday, it's the age group is 42 and higher that the NHS are offering vaccinations to. So clearly, if you're below that age, generally speaking, you won't be able to get the vaccination. I know certain people can get it under that age, but generally not. So if that's a bar to employment, if you're under 42, clearly that looks like indirect age discrimination. Disability. Well, disability in itself shouldn't prevent you getting vaccinated. There's some people who have severe allergies that are recommended not to have the vaccination, but generally disabled people should be able to have the vaccination. But I'm thinking of people maybe who've got a mental impairment or an anxiety type condition that makes them very worried perhaps about having the vaccination, and that condition could also be a disability if it meets the test under the Equality Act. So they might be caught by this. Pregnant women, the advice when I checked yesterday was it seems that if you're pregnant, generally you should wait for the pregnancy to be completed before you're vaccinated. And religion and belief. Now that's an odd one, but these regulations, the regulation and belief, sorry, the religion and belief regulations are a developing area, and many unusual things have been held to be protectable beliefs under the law. So, for instance, the belief that fox hunting is cruel was held to be a protectable belief under these regulations. So the views of anti-vaxxers, people who think that the vaccine and the pandemic is a conspiracy theory, arguably that might be a protectable belief under the regulations. I'm a bit dubious, but it's potentially arguable. Unlawful deduction from wages. So there I'm thinking of the situation where perhaps somebody refuses the vaccination and then you suspend them without pay, or perhaps they miss out on some opportunity to earn in some way, perhaps because you've changed their job, because you've moved them, because you put them somewhere where they're not going to be in contact with other workers, and that affects their earnings. That could be, if it's not within the contract, which would be the case if they haven't signed a new contract, that would be potentially unlawful deduction from wages. Finally, data protection. I'm going to look at that, but not just yet. I'm going to look at that a bit later when we look at workplace testing. So just the final slide on this, and thinking about overall possible approaches. Well, I think there was sort of three really I put on the slide there. I think most employers are just not going to get into all this. They're just going to do nothing. They're just going to leave it to people as to whether or not they want to be vaccinated. At the other end of the scale, you've got the mandatory requirement, and so care homes, people working in healthcare provision where they're in very close contact with members of the public. They're going to be at that end of the scale perhaps. And then in the middle, I think a lot of people might just take this view that they'll encourage the vaccine, they'll try to educate the staff to it, but they won't make it a requirement. Just going back to the first slide, no need to move it, Nicola, but where you are saying to new recruits, you've got to have the vaccine, although that's caught the headlines, I think it's probably fairly low risk that if you said you can't have a job here unless you get the vaccine, that's probably fairly low risk. Such claims, even if they succeeded, would only be for injury to feelings, and one wouldn't have thought that those would be very big awards. So probably that's not a big risk for you if you took that approach. The other issue of dealing with your existing workforce and requiring them to have the vaccine, that's different. That is fraught with difficulty, it seems to us, as we've discussed on these slides. So think carefully before you introduce such a requirement. Okay, so I'm going to leave it there, and now Nicola's going to talk about coming back to work, I think.
Thank you, David. So now that we've discussed, sort of considered whether employees can be asked to have the jab, what will the actual return to the workplace look like? So will it be a return full-time? You're going to be working from home permanently, or are you going to be taking a blended approach? Now, Rishi Sunak told the Telegraph recently that employees will vote with their feet if they're required to work from home full-time once the country has emerged from lockdown. He actually commented that home working is no substitute for an office environment, in particular because you can't beat the spontaneity, the team building, the culture you create in a firm or organisation from people actually spending physical time together. He also actually argued that an office environment was particularly important for younger workers, as it would help them actually understand how the company works. He felt that it was important that we try to get back to a good degree of this. Now, obviously, every employer will have their own view as to whether or not they actually agree with the Chancellor or not. And these comments came amid several reports that bigger offices and companies were closing some of their offices, and people would be required to work at home on a permanent basis. And one of the companies that recently made this announcement was Nationwide. They said they were closing 3 offices and that 13,000 people could work from home and basically be anywhere in the country. Obviously, for some employees, they're going to be overjoyed at the aspect of working from home permanently. Could be very beneficial for them, as they no longer have to be within commutable distance of the offices. But for others, it may make them want to look for alternative employment, as they may not want to work from home permanently because they would miss that social aspect. And also there's the risk that working from home, your home and your work life becomes mingled into one, and there's no sort of distinct separation between the two of them. So just in comparison then, Indeed produced an article stating that the office is not dead, and said that 60% of the jobs that were posted were only posted as being temporarily remote during lockdown in the early part of 2021. So this is showing that once all the regulations and guidance are eased, then potentially people would be going back to the office. So what is the current guidance about being in the workplace? Well, as you know, we're currently in step 2, and that states that people should continue to work from home where they can and minimise domestic travel. Then step 3, the roadmap, which is no earlier than the 17th of May, states that the government will advise the public to work from home where they can. And then prior to step 4, which is obviously due no earlier than the magic date of the 21st of June, the roadmap actually states that the government will be undertaking a thorough review of social distancing measures and other long-term measures that they have implemented, including the actual review of working from home. So until the actual roadmap, the review is completed, the roadmap actually states that people should continue to work from home where they can. So potentially after step 4, so after the 21st of June, hopefully a lot of the precautions such as social distancing and face coverings may be disregarded. However, until we've actually had sight of that final review, we must all continue and comply with the current requirements. So if you intend to return to the workplace prior to that review being completed, you must ensure that you review the government guidelines for your specific workplace. Now, there's a lot of recommendations, but mainly they include undertaking a risk assessment, social distancing throughout the workplace, having hand sanitizing stations, encouraging frequent hand washing, opening windows, using screens to separate people within the office, and potentially back-to-back or side-to-side working instead of face-to-face, and also including the need for enhanced and regular cleaning. Also, as just a practical step, you may well try to limit social contact by limiting the number of employees in the kitchen, for example, at one time, and maybe implementing staggered start and finish times. Now, as David said, you will have some employees that either do not wish to have the vaccine, cannot have the vaccine, or they may simply be anxious about the return to the workplace, especially if they've been working at home for over a year now, since we all started the home working on the 23rd of March 2020. So if they are anxious about returning, and you ask them to, you should listen to what their concerns are, and try and be sympathetic and supportive. Explain and look into what the actual public health advice is at the time. And it's really just trying to find out that specific reason, you know, what is their concern? And explaining to them about the steps that you've taken to ensure that your workplace is as secure as it possibly can be. So what would happen if after these steps, the employee still refuses to attend the workplace and simply says, no, that's it, I'm going to work from home? If that return to the office is requested after the 21st of June, or the actual date that the government completes the review and has confirmed that all employees can return to the workplace, then it's likely to be considered that you're making a reasonable request for the employee to return. Therefore, if they do not, it may be that you can consider disciplinary action on the basis that the employee has failed to follow a reasonable management instruction, or it could be that you consider that it's an unauthorised absence. Now, as David referred to, you will have employees that are suffering from severe anxiety, which prevents them from attending the workplace, and also could be considered to be a disability under the Equality Act. So if that is the case, you would need to consider making reasonable adjustments for them, which may mean that if they can do their job from home, you may need to allow them to continue working from home. And also it would be advisable to obtain medical advice to see how you could potentially support them as well. However, if you dismiss an employee prior to that final review, when the government has said that it's safe for people to return to the workplace, and the employee is dismissed because they're refusing to attend the workplace due to their concerns about catching COVID-19, then potentially they could bring a claim for automatic unfair dismissal under either section 44 or 100 of the Employment Rights Act. So both of these sections protect the employees from receiving detrimental treatment if they have actually raised concerns where they reasonably believe that there is a serious and imminent danger to their health. So as some of you may be aware, we have been waiting for any cases to appear on this, and we have had the first judgment from an employment tribunal in this matter. It's the case of Mr. Rogers and Leeds laser cutting. And in this particular case, it was regarding a claim under section 100, where the employee actually refused to attend the workplace as he had a child with a chronic condition and believed the workplace to be unsafe as he could catch COVID-19. Subsequently, the employee was dismissed. Now, the actual tribunal found in favour of the employer, as they felt that the employer had actually provided for social distancing, and regular hand washing. And they found that the employee had not specifically raised health and safety concerns in detail with his employer. So this case is actually just being heard in the employment tribunal, and it's not actually binding on other tribunals. However, it does show that the judge will actually look at all the facts carefully, and the judgment that they provided was quite detailed. If you're interested and would like to see a copy of the judgment, please just pop your name into the chat and we can get the link sent out to you. It's all about if you're not intending on going back to the workplace at all, and just wish to continue with home working because it's worked well in your business. So you'll obviously need to inform employees of the decision and ensure that you actually have, or they have, the right equipment at home. It may be that because we all suddenly rushed into the first lockdown, that you sort of provided equipment hastily and not now entirely sure what equipment was provided at the beginning, and therefore it would be a good idea to undertake an audit to find out what equipment the employee has, whether they are using yours, their own equipment, and what they would actually need to be able to continue working from home. It would also be advisable to have a home working policy, which would identify the need to keep equipment and data and documents safe, and also to ensure that they're complying with the data protection policy of the company. It's also important that you undertake a safe and suitable sufficient risk assessment for home workers to ensure that they are working in a safe and appropriate environment. So David, apart from the requirement of having a vaccine, what else could we do to make sure that the workplace is safe?
Thanks, Nicola. So workplace testing is what the employer might be looking at. Now, this is something that you might have been doing for a long time, depending on the nature of your business and whether or not people can work remotely. But we're thinking about this in the context of society opening up and restrictions being rolled back and more people being brought back to work. So why might you want workplace testing? Well, it's another way of reassuring staff, perhaps, that you're serious about your health and safety duty. You may be genuinely concerned that someone's going to come into the office. Maybe the layout of your premises is such that if somebody was infected, that they could infect the whole workforce and shut you down. It's going to depend on your business and the layout of your premises and so on. But anyway, if you do this, there's some things to think about. Types of tests you might do. I mean, we're mainly thinking about the ones you can get, the kits from the NHS, the lateral flow tests, which are the ones that kids are bringing home from school to use, although that's voluntary. You might do other types of tests. You might do temperature tests. You might just get someone to fill out a questionnaire about whether they've had symptoms. But we're mainly thinking about the test kits. What do you need to think about if you're going to do this? Well, you really should have a written policy on this. That would be wise. And again, as I was saying with the vaccination, ideally you would consult staff with that to get them on board with it. And that written policy would set out why you're doing it, how the tests are going to be done, who has to have them, how often, and so on. And it's going to need to say what happens if there is a positive test. I mean, clearly the law is still, if you test positive, you've got to self-isolate. So if they're at work, which presumably they would be, otherwise you wouldn't be testing them, you've got to send them home. You've got to suspend them. And if they can't work for you at home, then they're going to be suspended from duties. So if that happens, what are you going to pay them? That needs to be dealt with in the policy. Now, if you suspend someone, they can't work from home, so you send them home because they've had a positive test, there's a good reason to maintain full pay. Now, it's obviously, that's expensive. You're not getting any work out of them, but you are bolstering your whole reason for doing this, i.e. the good health and safety of your workforce. Because if people fear they're going to have their pay cut, then they're more likely to avoid tests or refuse to have them. So if they know that they'll get paid if they have a positive test, if they're sent home, it's going to encourage them to cooperate. ACAS mentioned that you could furlough staff if they've tested positive and sent home. I think it's arguable that that doesn't actually fit in with the rules of the coronavirus job retention scheme. I'm not entirely sure about that. It seems to be a risk to me, that furloughing staff in those circumstances. What about if employees refuse to cooperate? Well, if this is your policy that you're going to have this, then you're going to have to enforce it. You can't allow people to pick and choose. That's not going to work. So we are looking at disciplinary action if people refuse workplace testing. Again, it's going to be, if there's a written policy, this is what the company have decided to do, then it will be a reasonable management instruction to require people to do the test. If they refuse, that's misconduct. So they could receive a warning, and clearly if there's repeated breaches, that could be a dismissal matter. And then finally, picking up on the data protection issues, and I mentioned this applies to the vaccination data as well, because clearly that kind of data, that's quite sensitive. That will be personal data. You need to have, under the UK GDPR, a lawful basis for holding that data and processing that. If you don't, the ICO have got some jurisdiction there to issue fines, potentially very large fines, if employers are not complying with data protection law. So I mentioned your written policy. You might deal with it in there as to why, what you do with the data, how long you keep it, when you'll delete it, and so on. That could also be in the other documentation you have to do with data protection. So you may have privacy notices for staff. You may have a data protection policy or a privacy standard. They've got a variety of different names. But anyway, in your documentation to do with data protection and privacy, you might say something in there about data for vaccinations and workplace testing. Thanks. Over to Nicola.
So what payments are your employees entitled to if they are off sick due to COVID? Well, sure, as many of you are aware, or probably all of you, an employee is entitled to statutory sick pay if they've been absent from work for 4 or more days. First 3 days are unpaid, and the rest will be at the statutory sick pay, which is set in April each year. The current statutory sick pay is £96.35 per week, and that's payable for up to 28 weeks. So the actual statutory sick pay regulations have been amended in light of the pandemic, and statutory sick pay is also payable to employees that are shielding and unable to work from home, self-isolating due to experience symptoms of COVID, or living with someone who is isolating due to having symptoms of COVID, have been advised through the contract tracing system that they're required to self-isolate, have been informed that they need to self-isolate prior to undergoing surgery. So as I said, employees will only be entitled to statutory sick pay if they are off work for 3 or more days. So therefore, if an employee has actually isolated for only 3 days, then got a negative test result and can return back to work, they would not be entitled to any sick pay whatsoever unless you have company sick pay policy. However, if they are absent for 4 or more days, then they will be entitled to be paid statutory sick pay from day 1 of their illness. Now, also employers with less than 250 employees are entitled to a claim statutory sick pay from the government for the first 14 days of a COVID-19 related absence. So the notification for absence is also different for those employees that are absent due to COVID. Obviously, normally employers are entitled to ask employees for a fit note from their GP after the first 7 days of sickness. Now, in COVID-related absences, the rules provide that an isolation note from NHS 111, which employees can actually complete themselves online, is sufficient, or notification from the NHS or Public Health England confirming that they are required to isolate, or a letter from their GP or the NHS telling them that they need to shield. So if an employee is not unwell and isolating due to being in contact with someone who has tested positive, you may wish to discuss with them working from home, if possible, rather than being placed on statutory sick pay, as it's probably going to be a more favourable solution all round. Also, if an employee starts exhibiting symptoms of COVID-19, again, you send them home to self-isolate. They're actually not that unwell. It may be the case, again, that they can work from home during that period of isolation. However, if you have sent them home due to exhibiting the symptoms of COVID and you're acting within the government guidelines, then potentially you could just pay them the company for statutory sick pay. However, if the medical grounds are different to those identified in the government guidelines, and you've sent them home from work simply because they appear to be ill, then you may well have to pay them the full pay for that period. So David, can you tell us about holiday?
I will try. So annual leave. Now, we just mentioned this because there was some change to the law about this because of the pandemic. I'm just going to deal with that. So the normal rules on annual leave are that you generally can't carry it forward, or at least there's usually restrictions about the extent you can do that. I mean, there's some cases based on European law providing the ability for people to carry forward leave, for example, where they've taken statutory leave or they're on long-term sick leave. But anyway, these regulations were introduced about a year ago, actually, shortly after the pandemic started, and they enable the up to the 4 weeks, this is the working time directive leave, to be carried forward up for 2 years where it's not reasonably practicable for the leave to be taken because of the effects of the pandemic. So first thing to note there, this only applies to the 4 weeks working time directive leave. It doesn't apply to the extra 1.6 weeks that you get under the working time regulations, or indeed any contractual leave on top of that that they may get under their individual contracts of employment. So it's just the 4 weeks EU working time directive leave. ACAS and the Department of Business, Energy and Industrial Strategy have given some advice on this, and they've given some examples of cases where it may be relevant, and they're on the slide there. So employee sick, and as I say, there was already some provision in law for people to carry forward leave when they're sick, but they so that was limited to 18 months actually. When someone's on long-term sick leave, they can carry forward leave up to 18 months. So this is up to 2 years if sickness prevents them, sickness related to the pandemic, that is. You know, if they're sick with something else, that's not going to be affected. But if they were sick with COVID, and that caused them not to be able to take their leave, then they could carry it forward for up to 2 years. Employees on furlough, now, of course, we've learned, we didn't know in the beginning, but we realised over time that people could take holiday whilst they're on furlough. But if that happens, you, as you probably know, you have to top up their holiday pay to the full rate. You can't pay them the holiday at the 80% capped at £2,500 a month. That's the limit under the coronavirus job retention scheme. So you've got to pay them their full pay. So there might be cases where, depending on your business, if you just can't afford to do that, you may say to staff, you'll just have to carry forward the leave. So that could be a relevant case where people on furlough could take forward the leave. And then the other example they give is where the employer requires the employees to continue working and not take leave because they're so busy providing whatever goods or services they provide because of the effects of the pandemic. So, for instance, I don't know, delivery drivers, perhaps, yeah, some sectors have been very busy, haven't they, during the pandemic? So, okay, so that's a situation where it's envisaged that people just won't be able to take leave because of the pandemic, so they can carry forward the leave. That's a bit risky to my mind. I mean, it's just not a good strategy to keep people working without leave for a prolonged period of time. Obviously, people need rest. If you don't let them have rest, they're going to burn out, they're going to become sick. It will just be counterproductive, perhaps. So that's risky. The other one not mentioned in the advice, but which is probably the one that I've come up against more, is organisations where people are not taking the leave because they've cancelled their leave because we're in lockdown and they can't go abroad or they can't go to their holiday home or wherever. And so they're just accruing leave. Now that's arguable whether or not that is sufficient to make it not reasonably practicable so that the regulations would be engaged, allowing them to carry forward the leave, so they could use that as a justification, i.e. come to you and say, I'm entitled under these rules to carry forward my leave because I haven't been able to take it. I think that's a bit flimsy, and I think employers are entitled to manage that situation and say, you know, sorry, you can't go abroad or you can't go to Cornwall or wherever, but you can take leave. You can, even if it's at home, you can rest. So we require you to take leave because we can see, can't we, that problems are going to be stored up for the future if you're allowing your workforce to carry forward large chunks of leave, because eventually they're going to want to take that leave, and if they all take it together, you won't be able to operate. So you really need to manage that. I don't think you need to be afraid of employees using the regulations as a mechanism to allow them to carry forward a lot of leave. You can insist they take the leave, and there's a mechanism under the working time regulations to make someone to take leave. You have to give them notice, and you have to give double the length of notice of the period you want them to take. So if you want them to take a week's leave, you must give them 2 weeks notice of that. Okay, over to Nicola.
So long COVID, then, is it a disability? So the National Institute for Health and Care Excellence identified post-COVID-19 syndrome as signs and symptoms that develop during or after an infection consistent with COVID-19, continues for 12 weeks and are unexplained by an alternative diagnosis. A systematic review has actually shown that there are at least 55 different long-term effects. So I've just put some of them on the slides. These appear to be the common symptoms: tiredness, difficulty sleeping, feeling sick, loss of appetite, high temperature, shortness of breath. And you can obviously see all of those on the slide. And the number of people actually suffering from long COVID is still sketchy at the moment, but in December, the Office for National Statistics estimated that 1 in 10 people testing positive for COVID-19 and had actually replied to the survey had exhibited and would exhibit symptoms for a period of 12 weeks or more. So there are people out there suffering from long COVID, and it's potential that one of your employees may well be suffering from it. So looking at it and whether it is considered to be a disability, we need to first of all look at the definition of the disability under the Equality Act. And that states that it is a physical or mental impairment that has a substantial and long-term negative effect on an individual's ability to undertake normal day-to-day activities. So looking at all those potential symptoms of long COVID, it is certainly possible that an individual could show that they are suffering from a physical or mental impairment. As to whether the effects will actually be substantial is obviously going to depend on each individual. For example, if you have an individual who has to rely on oxygen most of the time, then obviously that's going to be a substantial negative effect on their health and well-being. So for it to be long-term, it needs to have lasted or is likely to last for a period of 12 months. And also any tribunal would look at how the illness affects their day-to-day ability to do things. And that's just normal things such as getting dressed, getting up, going shopping, and sort of the day-to-day aspects of your own sort of normal life. So due to a range of symptoms and the indication of the amount of time that an individual could suffer from long COVID, I certainly consider that there is a potential for long COVID to be considered a disability. And therefore, if you do have an employee who has long COVID, I think it's very important to take it seriously and act as though they potentially have a disability under the Equality Act, which may mean looking at making reasonable adjustments for them so that they can either return to work in the workplace, or it may be that you have to look at them continuing to work from home. Changes potentially within the workplace that you could help them with are maybe working reduced hours, staggered start and finish times, and just offering the general support that they may need. They may need things like regular breaks, somewhere to be able to go and have a rest. As I've said before, it's always useful to obtain a report from an occupational health advisor. Then again, they can provide you with recommendations as to how you can support your employee back to the workplace. Now, I'm sure that we've all heard stories of people who've contracted COVID. You've got those that maybe just suffer from a minor cough, or obviously you've got the one that is in the media about Derek Draper. Now, just quickly, I'm just going to give an update on the coronavirus job retention scheme. So the scheme was actually implemented in March 2020, when we went into that first national lockdown. It's actually reported that more than 125 organisations that claimed at that time are actually now beginning to pay back the money that they received under the grant. Out of interest, these are some well-known companies such as IKEA, Barrett, Taylor Wimpey, Halfords, many sort of household names. The amount of jobs that's being reported as being supported by the scheme at the end of January 2021 was 4.7 million jobs. And they've said that over the whole period of the scheme has actually protected more than 11 million jobs. I think it will be interesting to see what actually happens when the scheme comes to a conclusion. So initially, the purpose of the scheme was to help those companies that had been adversely affected due to the pandemic and were unable to maintain their workforce. In particular, the pandemic has particularly affected companies in events, the leisure, the tourist, and the retail sectors. So over the months, the scheme has actually been extended on a number of occasions, and it's currently due to finish on the 30th of September 2021. So one of the main changes of the scheme was the fact that they introduced the flexible furlough, which meant that people could work reduced hours, and for the hours that they would normally work, they could, and were not working, they could be placed on furlough, and the employer could claim from the scheme for those hours not worked. So whilst on furlough, an employee actually gets up to 80% of their salary, up to a maximum of £2,500. So initially, the amount that could be claimed from the government was the 80%. But as you'll note from the slide, this will now be reduced in July to 70%, August and September to 60%. But remember, although you can only claim 70 or 60% of their wages from the scheme, the employees are still entitled to 80% of their wages and up to the cap of £2,500 until the 30th of September. So for those staff that you've placed on furlough since the commencement of the scheme, you must ensure you keep a written record of the agreement, and also for up to 5 years, and also keep records of the number of hours that employees have worked, and also on the flip side that how long they have been placed on furlough. As it is possible that HMRC may well undertake investigations of companies over the next few years and ask to see that documentation. Out of interest, in September 2020, HMRC actually identified that 5 to 10% of furlough cash had been wrongly awarded, and that they were investigating 27,000 high-risk cases. In addition, it's just important to remember that whilst on furlough, employees cannot undertake any work for you whatsoever. They can undertake training and they can volunteer for other organisations, and in fact they can also be employed by other companies and undertake work for them, but not for you. You are still able to place employees on furlough should you need to do so. However, as the country is now opening back up after lockdown, hopefully you won't be needing to use the scheme. So that actually brings our talk to a close. I can see that we're actually slightly over time.